This case opens inside a Texas courtroom where everything is already on the line. A defendant with a long repeated criminal history is standing before the judge for sentencing. And what's about to unfold is not a routine hearing. Prior convictions, enhanced charges, and a plea deal already on the table. But the real question is, will the court show mercy, or has the pattern of behavior already sealed the outcome? Stay with this, because the judge is about to break it all down in detail.
Good morning. Are you Veronica Randall?
It's Your Honor.
And Ms. Randall was previously in court in clause numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, sure.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate?
No.
There we go. No additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yeah, sure.
All right, Mr. Vasquez, you may proceed with argument.
Your Honor, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and if the court thinks best would help her to quit offending. And in lieu of that, in the alternative, Your Honor, I'd ask for something less than the 6 years if she's willing to.
Anything else, Ms. Malfini?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors that would enhance anything further. But if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires
This is where the
or
courtroom
makes.
tone shifts hard. The judge is now laying out decades of prior offenses, starting all the way back in 1981. Not just one or two mistakes, but a continuous pattern. Thefts, robberies, aggravated robbery, and multiple felony convictions stacking over time. Legally, this matters because prior convictions dramatically enhance sentencing exposure and reduce the likelihood of probation. The judge is essentially questioning rehabilitation versus repetition. Are we dealing with circumstances or a cycle that never stopped? And that's the key tension here. Should the system still offer leniency when the record shows repeated failure under supervision? What would you do if you were sitting on that bench?
Is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob because, I mean, we've got robbery, aggravated robbery, another robbery. Anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25, DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. In cause number 26, DCCR 0312, find sufficient evidence to find you guilty and find all those counts true. And in that case, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0315, find sufficient evidence to find you guilty and find all the prior convictions that you pled true to true. And at this time, find you guilty of theft of a firearm, find those convictions true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 26, DCCR 0316, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated kidnapping.
This is the final outcome of a multi-case sentencing hearing where the court imposes stacked prison terms ranging from 6 years to 35 years across multiple felony convictions, all ordered to run concurrently. Legally, concurrent sentencing means the defendant serves all terms at the same time, but the longest sentence effectively controls total custody duration. The judge also issues a firearm prohibition warning and confirms waiver of appeal rights, finalizing the judgment. This case highlights how persistent criminal history, enhanced charges, and prior failures on supervision can push sentencing toward maximum statutory exposure rather than rehabilitation alternatives. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Kidnapping, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these cases will run concurrently, which means together at the same time. It shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. Right now, you can go back with the bailiff.
Thank you.